Hi, everyone. Harry here to talk about the first response back of Judge Hannah Dugan, the Wisconsin Superior Court judge who has been arrested on charges of basically harboring a immigrant who was here unlawfully and that ICE wanted to arrest. Okay, you recall the basic story, right? There's somebody in her courtroom and a force of six feds from different agencies have come in to arrest him. He's there on charges, fairly serious charges, I think, of domestic violence. He shows up, he's complying with the law, and they're ready to just spirit him away and arrest and deport him as soon as he leaves the courtroom. Dugan gets wind of this, doesn't want it to happen. In fact, is irate that they're coming into her courtroom or otherwise disrupting proceedings. There's meetings and with the chief judge and the agents, etc. At a certain critical juncture, which will be the sort of core of trial if it goes to trial. Ruiz, the person they want to arrest, goes out the door, not of the front door of the courtroom, but the door in the jury room. And the allegation, at least in the complaint, she denies it, but the allegation in the criminal complaint that's been brought is basically she escorts him there in order to elude detection and apprehension by the agents who are there to get him. He goes out that door. He's still in the same hallway. One of the agents sees him, follows him down an elevator. The other agents join. They chase him. He does run away, but just the length of the building. They catch him, arrest him, etc. Okay. They charge her with, and more than that, I've talked about this before. It's including in my Substack, but the Attorney General calls her deranged. It's really characteristic and pretty obnoxious overkill by the United States to do. Okay. But her first parry is a legal one. She says, I'm a judge. Judges have judicial immunity. That means if we're doing our jobs, you can't charge us with a crime. If they are, let's say, pronouncing from the bench and they defame, they can't. That's just part of doing their job, and they have immunity. That's a long-standing common law principle that Congress hasn't abrogated. A really important aspect of it. So she's saying, because I have immunity, you can't charge me. You got to dismiss this conviction, and you certainly can't convict me. And this strikes me as potentially pivotal, my subjective intent becomes irrelevant. If I have immunity, it doesn't matter why I'm doing what I'm doing. So you can allege all day long that I was trying to help him escape, but that's not relevant evidence, and that should be outside the case. So what does that leave? That leaves my story, which is basically I was doing this because I wanted to control my courtroom, and part of my official responsibilities are to control my courtroom. I wouldn't have judicial immunity if I was, in the public square. But you come into my courtroom, or you try to mess things around, wait till he comes out the front door, cause a ruckus and disturbance, etc. That is a violation of my judicial immunity. You cannot punish me for what I did there. So there's a little bit of competing narratives where she's basically saying, I want to control my courtroom from the feds. And, on the evidence, there's a pretty strong point. It's important to see, maybe for a future YouTube, I'll try to get a diagram. But, when he exits the jury room, it's not as if it's a separate, exit that gets him out of the eyesight or scrutiny of the agents. What it does do, though, is prevent any kind of disturbance in front of the courtroom itself. So pretty strong argument that on the facts, it just doesn't fly. But she's saying it doesn't matter. It's fact. I'm a judge. And the only issue is, am I doing my official duty? Telling even under your version of things, telling a defendant in my courtroom where to go, setting the next hearing, even suggesting, as you're telling me I did, that I will do this or that in a subsequent hearing in order to prevent a arrest. That's my courtroom, guys. And stay out of my courtroom. That's what the law requires, both judicial immunity and hovering in the background here, and we'll be seeing this, is a basic argument under the Constitution that Congress doesn't have the power to, when they passed a law, to the extent it sounds like, just reading it, would apply to a judge. They don't have the power to do it, so that's a violation of the Constitution. And moreover, they didn't do it. So if this idea is accepted, we'll see what Bondi and company try to say in response. They'll basically make some kind of argument to really parse it very finely and say, at the moment she's telling him to go out the door, which is a disputed fact, but at the moment that's not her official capacity. Her official capacity is being on the bench, etc. They will try something like that, I think. If Dugan wins the immunity motion, this principle of it, that subjective motivation is irrelevant, becomes very powerful, because basically it means that the United States will not be able to argue that she was doing it for this reason rather than that reason. I've always thought this case won't hold up and will fall apart. It may fall apart early on the strength of this very motion, but if not, I think when it comes to the evidence and the thrust and parry of the different versions, that they will be, the United States, very hard pressed to prove theirs beyond a reasonable doubt, and it's all going to look like overkill, as indeed it was, arresting a judge for conduct having to do with her own courtroom docket of defendants and the like. So the first claim to dismiss it is a straightforward legal one. I have immunity, end of story. Can't charge me, can't convict me, subjective motivation doesn't matter, etc. And if that's accepted by the federal court where she's been charged in Milwaukee, it should be the ballgame. If not, we'll go into evidence discovery and the like, and that as well, I think, will be not very favorable for the United States. But first, they might just lose it on the very principle that you can't just come in and charge a sitting judge who is doing official activity in her courtroom. So it's a motion that says under the law. It doesn't matter what the facts are. I am, under the law, legally entitled not to have been charged here. Please dismiss the complaint against me. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.